Loading. Good afternoon and welcome to Fridays with Friends. You're lucky to be joined today by the managing attorney at Sunshine State Probate, Nathan Nevins. Good afternoon, Nate, and we're excited to learn a little bit more about probate. Nate, take it away.
Hi, everyone. My name is Nathan Nevins, and I'm the managing attorney at Sunshine State Probate. We do probate administration throughout the state. Just a little bit about myself. I was a public defender for 3 years, then I was a general practitioner for about 5 years, and I did probate administration. But now I'm just focusing on probate administration throughout the entire state of Florida. These cases are generally ex parte, which means it's just one side, it's uncontested. I like to basically say it's kind of like transactional law with a judge kind of overseeing every step of the way. So I truly can practice statewide because it's not like I'm going to hearings and stuff like that. So the reason why I do like the probate practice is because you, like many types of law, you really help individuals get through a tough time. And of course, there's a death of a loved one, but by the time it's all said and done, people usually do have some closure. So that's very, very nice. So what is probate? A lot of attorneys that I talk to, people I know from law school throughout the practice and other places, they really don't even know what that is. When I told some attorneys that I was focusing on probate, a lot of them told me that they had to actually look up what that was. So probate's a court supervised process to identify the assets and creditors of a decedent. A decedent is a person who passed away, pay off their debts, and then ultimately distribute their assets to their beneficiaries. So a lot of times, you know, you'd see in a movie or TV, something called reading of the will, which a bunch of heirs go into a lawyer's office, they pull out a dusty old will, they read it, and the person walks out of the office with a check or the deed to a house. Unfortunately, it's not that simple. It's not that simple, and it doesn't quite work like that, but that's just Hollywood type stuff. So probates can be conducted with or without wills. Another misconception is some people think that just because you have a will, you don't have to go through probate. That's actually not true. A will is instructions to the court actually how to conduct the probate process. Not only will it identify who you want to leave your assets to, but it also speeds up the process. In many counties in Florida, they make it a little faster. If you do have a will, there's less steps to take, which is of course very nice. So there's two different types of probate for the most part. There are a couple others that I'm not going to get into, but the two most popular types are a formal administration. So this is the full probate process. This is when a personal representative, which is commonly referred to as an executor. In Florida, it's actually legally called a personal representative, is actually appointed. So the important part about that is that that person is able to conduct business on behalf of the estate. So we're talking about selling property, entering contracts if needed. And most of the time, what you'll really need it for is if taxes need to be filed. We're talking about the IRS income taxes. So that's what the formal administration is. There's also a short version of probate, which is called a summary administration. It's a bit quicker. You don't go through the full process. And actually, there is no personal representative that's appointed. There's special rules, which means an estate only qualifies if there's less than $75,000 in assets, or if it's been 2 years since the decedent has passed. The problem with these are, first off, no one has the legal authority to act on behalf of the estate. So if you need to sell property, You can't do that. There's issues with filing taxes with that as well. Usually the IRS wants to see the paperwork that you're actually appointed personal representative to file taxes on their behalf, and you do need to take care of that person's income tax. So sometimes, even if there aren't $75,000 in non-exempt assets, you still have to do formal administration. And then also, this is what's really difficult to do a summary administration, is you actually need to know the exact amount of the assets, because you petition the court for a proposed distribution, and the court, you need to notice certain people and do certain things, and then the court either grants it or denies it. It's not like you have the ability to go into people's to the decedent's bank accounts and find out how much money there actually is. You need to know the exact numbers and the exact assets to do a summary administration. So a lot of times it's just not practical, at least not to start off. You can start off with a formal administration, get the power as a personal representative, find out about what kind of assets they have, what's in the bank accounts, et cetera, and then you can convert it to a summary if it qualifies. Sometimes we'll do that, but there are limitations for the summary administration. So those are the basics. But since this is legal aid, of course, I wanted to focus on some things that might be relevant for not only people watching on Facebook, but also the possibly attorneys that are watching that are involved with legal aid, and that these are not necessarily the most sophisticated clients. Obviously, they're not clients with incredible wealth. They might be clients that have a significant amount of debt. So what I really wanted to cover was exempt property and property that can be actually immune from creditor claims. I wanted to quickly go over estates that might be upside down and why it still might be worth it to open a probate, even if there are a ton of creditors. So let's kind of just jump right into the exempt property. So there's two main types of exempt property. We have statutorily exempt property, and then we have the constitutionally, we're talking about the Florida Constitution here, exempt property. So statutorily exempt property is only for a surviving spouse, or if there is no surviving spouse, for the children of the decedent. Remember, the decedent is the person who passed. This is Florida Statute 732-402. So the things that, when we talk about exempt, we're talking about exempt from unsecured creditors. So we're talking about household furnishings, appliances, furniture up to $20,000. Just so everyone knows, from a practical perspective, you will rarely see a probate open just for personal property like this, because there's not necessarily, a title to transfer. Usually it's done informally, even though you're not supposed to do that. That is not legal, but that is what usually happens. And that's not always the case, though. So for instance, I recently did a probate where the decedent owned a jewelry store. And so she actually had 3 daughters, and she specifically bequested all of these different types of jewelries to each of her daughters. So, sometimes you will actually go through a probate for certain types of personal property. And of course, if personal property is in a safe deposit box, then you have to do it, because otherwise they're not going to let you in that safe deposit box. So you have the household furnishings, appliances, and furniture up to $20,000 as exempt. You also have 2 motor vehicles held in the decedent's name, regularly used by the decedents or members of their immediate family. So that can be quite valuable, completely exempt from non-secure creditors. And then, of course, you have 529 tuition plans, Florida prepaid plans. So you're talking about college tuition savings type plans. And then there's also, if the decedent was a teacher or school administrator, you have there's a statutory death benefits for them. Now, it's important to really explain what I mean by unsecured creditors, because some people might not know what that is. An unsecured creditor is someone who is actually doesn't have an interest in the property itself. So we're talking about if there's a car note, obviously the car note still has to be paid. You don't get the car free and clear of the car note. And then when we'll talk about homestead in the next section, a mortgage is obviously the most common secured creditor, meaning that they actually have a lien against the property itself. There are other sorts of secured creditors. For instance, if you're purchasing home furnishing off one of these payment type plans from one of these, places like an Aaron's or one of those, or Rent-A-Center, some of those businesses might actually have be secured creditors on those home furnishings. So buyer beware in these situations. You really need to make sure that there's no sort of secured creditor on this property. And then, of course, the big one, which is the homestead exemption in the Florida Constitution. So this applies to heirs at law, which essentially means the surviving spouse, if there is one, plus anyone who's a lineal descendant of the decedent's grandparents. So basically someone who is related to the person who passes grandparents. So we're talking about aunts, uncles, cousins, nieces, nephews, brothers, sisters, things like that. So often overlooked, there's $1,000 worth of personal property in the Florida Constitution. But of course, the very, very big one is the homestead itself, the house or the condo or the duplex or whatever that the person lives in, the decedent lived and passed away in. So if it's located in a municipality inside a city, it's only a half acre of the land. If it's outside of the municipality, it can be up to 60 acres. And these are exempt from all unsecured creditor claims. The heirs will actually get the property free and clear from any sort of unsecured creditor. And this is a big part of the probate practice. I mean, this is something that absolutely speaks to the legal aid client, because you'll probably have some clients who, maybe they've owned their family home that they've lived in for 30 years and they want to pass it on to their kids. They had medical bills when they passed, they had credit cards, all that stuff can't, touch the homestead, and their heirs will get it free and clear. So that's actually something that will be very, very beneficial for a lot of legal aid clients and just people in general. I mean, this happens all the time. So very quickly, I just want to go over upside down estates, because I know you don't want to hear me drone on forever about probate, even though I could talk about it all day. But the point I really want to make with this is that sometimes it will make sense to open up a probate, even if there are loads of creditors and not a ton of assets. And I'll just explain why. Because there's actually an order of payment from the estate that that Florida statutes direct for the personal representative to pay. So it goes into different classes. So the first payment for in an upside down estate, meaning that there's few assets and more debt than assets, is the cost of administration, the compensation of the personal representative, and attorney's fees. So right away, the personal representative gets a little bit of money for actually going through the process, and the attorney, the filing fee, all that stuff gets paid before any other creditors. But still, it's not just that. The very next class after that is funeral expenses up to $6,000. So a lot of times family members are the ones paying for that. So it could make sense that even if the decedent had, let's say they have a bank account with, $8,000 in it, that's their life savings. But that this person passed away with medical debt, credit cards, all this other stuff. It still could make sense to open up probate, because you'll at least get all the costs of probate paid for, plus funeral expenses up to $6,000. So even in situations where there's not a ton of assets and there are tons of creditors, it can still make sense to open up probate. And then before I leave, I do want to mention two quick things, which I did speak to Jeff about at length yesterday, which is something that people often overlook. And I know this actually happens a lot, especially with some of my more unsophisticated clients, and I might be the first lawyer they really ever spoke to in their entire life, right? After 2 years of the person's passing, all unsecured creditor claims go away. They're all barred. And this will happen pretty often, because I actually just finished one earlier this week where this happened, where um, a lot of times people just assume that, oh, they have a will, or they're the kids, they automatically get the assets when the person passes. It doesn't work like that. You do have to open up probate, but if, for instance, they've been living in the house for those past 2 years, or doing whatever with the house, after 2 years, all the creditors of the decedent unsecured are gone. So um, it's definitely a big positive, and can help with the probate process, can make it easier, faster. And the one caveat I will say with that is, of course, this doesn't apply to the IRS. The federal government always gets their money. So that's something that I always recommend clients talk to a CPA about. But that's the long and short of probate process, creditor claims, exemptions from, and upside down estates. So Jeff, I just want to thank you for inviting me. And again, at Sunshine State Probate, I'm on Facebook, like my page. If you have any questions, please reach out to me.
Thank you so much for joining us this afternoon, teaching us about probate, and especially those practical tips that you threw in. And thank you to everyone for watching. Keep posted for more events coming soon. Have a great afternoon, everyone.
Happy Friday.